the on-air button. Okay. All right. Welcome back after our 2-week hiatus, but we're on for the next couple of weeks. So, and then of course during summer we won't have to worry about staff meetings, so we should be able to go smoothly, except for when I'm on vacation. But that's not till after Shavuot, so we're okay. We are picking up on Sanhedrin 3:3, if my notes are correct, as we finished 3:2, talking about who was acceptable by permission of the litigants. But now we're going to talk about people that are disqualified from the beginning. These are people who are not allowed to be Adin, who are allowed to be witnesses. And it's an interesting collection. And we'll talk about how this works and why. So Mishnah 3, do I get a volunteer to read so that I have someone to interrupt?
Okay, I'll do it.
All right, yeah.
See, Steve twisted my head.
Well done.
Okay. So Mishnah 3.
Yep.
And these are they that are not qualified to be witnesses or judges.
Right, so technically either, but
Yeah.
we've been focusing mostly on witnessing.
Witnessing, okay. A dice play,
Meaning a professional gambler.
gambler.
Right, and we're going to see that that's the professional side is an important qualification. Keep going.
Assurer,
Usurer.
user,
So a usurer is somebody who lends money on interest,
which is not allowed.
which is not allowed, exactly.
Yeah. And then pigeon racers.
Think dog racer, pigeon
Pigeon
racer,
racer.
you know, it's like homing pigeons.
So what about cockfighting? Probably that's included.
Probably also not,
Yeah.
that's right. So, I mean, the pigeon racers, you know, you take your pigeons, you go somewhere and you say, I bet my pigeon will get home before your pigeon. And
It's basically gambling.
but it's a racing kind of gambling. It's not just rolling dice, but
Yeah.
it's a skill, maybe, you know. You know, you train the pigeons.
Yeah. Or traffickers in 7th-year produce. Or
All right, so well,
the Shemitah.
Shemitah. So here's the issue. Let's do a quick recap of Shemitah, right? So for 6 years, you work the fields,
Mhm.
right? And then in the 7th year, you don't work, but you are allowed to gather what grows by
By
itself,
Yeah.
right? You can pick up if you know, because especially in the pre-industrial farming sector, you didn't pick up every single bit of grain. It would have gone back as some dropped seeds. So there would have been some growing from the ground during that 7th year, and you're allowed to pick it up. What's being discussed here is somebody who picks it up and sells it, as opposed to picks it up and eats it for themselves. And that's going to be made clear in the second part of this first section. So go ahead.
Rabbi Shimon said, in the beginning, they called them gatherers of 7th-year produce. But after the oppressors grew many, they changed this and called them traffickers of 7th-year produce.
So it's a very interesting accommodation, because people who gathered in the 7th year, well, that could be everybody, but there were some people who gathered more than they should and were selling it to other people. But during the oppression, that this is after the Roman occupation and especially the Roman oppression, everyone had to work a little in the 7th year because of the Roman tax system and everything that was there. It was almost like they had to. And so they had to up the bar for who they were disqualifying. Because if you said everybody who gathers, then everybody is not going to be a witness. It's like, because everybody was forced to do this because of the Romans. So they had to raise the standard of being bad to not just someone who gathers during the 7th year a little more than they should, but somebody who's actually buying and selling in the 7th year when definitely they shouldn't. So because of the Roman oppression, everyone was forced to bend the rules a little bit, and so the standard had to be adjusted. And then Rabbi Yehuda is going to give us our important qualification. Oh, yes.
Back up to the lending money.
Yes.
And the interest act. I've not heard that.
Yes. So lending money for interest is prohibited by the Torah.
Yeah.
Really?
Nesher. It's called Nesher.
I've never heard that.
And it sounds a little surprising, especially because of some of the stereotypes about Jewish people and Jewish business and all of that. The Torah specifically, well, let's back it up. The Torah, when it talks about lending money, is embedded within the poverty legislation. That the section of the Torah that talks about it is talking about helping the poor. That was the idea that most people were used to, which was, your neighbor Bob, his farm has gone bust, and he needs to get back on his feet, and he needs to buy the seed to plant. His farm went bust. He doesn't have enough money for seed. He's barely going to be able to feed his family. So you don't have enough money to just give him the money to replant his farm, but you can probably loan it. You can swing that. If he pays you back, you'll be okay. That's what the Torah thinks of as being the standard of what you should be doing and what loaning means. In that situation, I think it's quite obvious, well, as long as I'm loaning him money, he should pay me 10% on the money. It would be a natural thing to imagine, and the Torah says don't even go there, right? When you loan someone money, you don't get interest on it. Later, the rabbis realized in a post-agrarian, or at least a mixed economy that wasn't only agrarian, there were reasons to loan money to people who weren't poor, for capital accumulation and buying and selling long-distance trade and things like that. And so we created other instruments that allowed for partnerships. So it was an investment rather than a loan that was a strict interest transaction. And the Torah did make allowances because of the difficulties of doing this outside your community, that if you were working with someone outside of a community because of the risk, because you no longer had the bonds of trust that would allow for the definite reclaiming of a debt, which we'll talk about debts and owing and litigation later, that you could charge interest almost as sort of a risk payment for dealing with people outside the Jewish world. And so when it came to the late Middle Ages, when Jews were forced out of most other businesses because of restrictive European laws, one of the few jobs that was left to us, because it was still prohibited to the Christians by the church, was money lending. And so Jews did do some money lending in the European to the non-Jewish community, because that was one of the few occupations that remained that we were allowed to engage in. So yeah, brief history on Jewish and money lending. But yes, to this day, especially if you're lending money to somebody who is in need, absolutely, it's prohibited to charge interest on that transaction.
So B, Rabbi Judah said, this applies only if they have no other trade. But if they have some other trade other than that, they are not disqualified.
Right. So if your job is gambling, that's your livelihood, we do not allow you to testify. Now, why would gambling or being a money lender or a pigeon raiser, why would these make you disqualified as being a witness? After all, it doesn't say somebody who eats pork can't be a witness. It doesn't say somebody who, does other transgressions, right? Works on Shabbat. They're specifying specific issues here. Now, trust me, it's no great honor, and you're not going to be invited to be a witness if you're breaking lots of other mitzvot publicly. But gambling isn't a mitzvah. Not gambling isn't a mitzvah. Right? It's not recommended. We don't speak highly of it, especially as a profession. But what's the issue here?
I think, just my thinking, because sometimes it's not completely black and white, it's kind of like a gray area, and the rules are bent different ways. Maybe that's the reason.
All right, so first of all, people who are professional gamblers have a reputation, because it's their job, of manipulating the situation to their advantage, of cheating.
Yeah.
And people who are habitual cheaters are not the kind of people whose testimony you normally trust.
You can accept.
But there's another problem with professional gamblers or people who are in this interest money market kind of thing, which is they become vulnerable to outside leaning, pressure, right? Ask anybody who has a bookie. If you are in debt to your bookie, there's a point where the bookie calls in the debt. And if the bookie calls in the debt by saying, tell you what, we'll call it even if you testify X, Y, and Z on my behalf, you're out no money, so it's a great deal for you. The bookie gets you to go say so-and-so owes him, $5,000. it's a win-win situation, except for the poor Shlemiel who's now getting false testimony against him. So there are issues of people here who are likely to be more influenced by others that could manipulate, twist arms, or in other ways change their testimony because of this vulnerable situation. So therefore their testimony is automatically considered suspect. On the other hand, somebody who's gambles, occasionally, we don't suspect them of being more susceptible for these problems. And so if we have evidence that they're obviously manipulating their testimony, fine, yes, absolutely disqualify them and punish as appropriate. But just because we found out the person went to Vegas last weekend, we don't disqualify them if it's just they went last weekend. Make sense? Good. It's all very rational.
Yeah.
3-4.
3, 4.
Now we're going to get a whole nother list of people who don't testify through no fault of their own.
Okay. Mishnah 4.
Right.
These are the relatives that are not they are not qualified to be witnesses or judges.
And this, by the way, comes up very often in my line of work because of weddings. Right? I don't get to do a lot of he owes me $100, no, I don't kind of cases. People don't usually come to the rabbi for that anymore. They go to small claims courts. But when it comes time for a wedding or for a conversion, making sure the witnesses, usually more often with a wedding, this is an issue, are not related to the bride and groom is important. And sometimes if it's a big family without a lot of additional Jewish guests, it can get, okay, hold on a second. We got to have somebody here who can be a witness. We arrange it in advance, of course, but it is something the bride and groom have to work out with the help of the rabbi in advance of the event. You can't just trust your luck that there's going to be somebody there who's not related. Because as we're going to see, the degrees of relation can get broad.
The suitor's father, brother, father's brother, mother's brother, sister's husband, father's sister's husband, mother's sister's husband, sister's husband, mother's husband, father-in-law, or wife's sister's husband, them and their sons and their sons-in-law, also the suitor's stepson only, but not the stepson's son.
All right, so you got that?
Big group of people.
It's a big group. Well, it's a circle, right?
Yeah.
So
Family.
Well, it's like family, yeah. But you have Mr. A, who is our potential litigant or defendant in a criminal case. The first degree of separation, right, is the father, the brother, and the son, right? The above you on the family tree, the next to you on family tree, and the below you on family tree. And by the way, in the ancient world, women were disqualified also as being witnesses. And partly that was because they were also considered to be vulnerable to influence by their husbands, so being forced to testify in certain ways because of the unequal power relationship in most of the ancient world. The conservative movement does allow women to be witnesses in the modern world, though. But we'll stick with the father, brother, son, because that is the language of the Mishnah. So you go up, you go out, and you go down. These are automatically disqualified. And then the other people are the offshoots of these relationships. All right, so it sounds really, really complicated, but really all you're doing is branching out. And then for some, like the father's sister's husband, there's a second degree branch that happens. And once you take care of that, boom, looks almost like a molecule chart. And you got your helium, your sodium. Then those are the circle of people who are not allowed to testify. Why not? Why would you not want family to testify?
Because they have interest to protect the litigant.
Exactly. Well, to protect or to
maybe
benefit from, right?
Yeah.
So one of the other ways to remember this, and that gets discussed a little bit more in the next section, is who inherits. Mm-hmm. If they stand to inherit somehow through the relationship, it is considered to be off bounds because there is a possible conflict of interest between well, I'm going to defend Uncle Bob because when Uncle Bob dies, I might inherit from him, and so I want him to keep his money. Or I don't like Uncle Bob, and or my cousins or nephew, so that I'm going to try and change things in a different way. So who inherits becomes a big issue because there's a possible conflict of interest between testimony and personal benefit. So family is not just family. It's not just you have warm fuzzies about Uncle Bob. There is a financial incentive to protect or sometimes distort the family relations, a testimony on behalf or against family relations. And that, they say blood is thicker than water, and cash is thicker than blood. So that the rabbis wanted to make sure that we didn't bring in a witness only to then have to question their motives for testimony. Onward.
Rabbi Yosef said, such was the Mishnah of Rabbi Akiva. But the first Mishnah taught a suitor's uncle or his uncle's sons and all that are qualified to be his heir.
Right. So he tried to break it down into a bit of a simpler rubric of, no, it's the uncle's son and qualified to be heir. That he's only taking it one direction. Now, the reason why this can be a little different is because inheritance only works in certain directions. So, my father's sister's husband's son, right? That's a sister. I wouldn't have to worry about because of laws of inheritance, because when he dies, it's not going to come to me because the sister never inherits from the husband. And therefore, there's no worry about me being having a vested interest. Whereas if it's just a matter of family degrees, then that would still be a concern. So there's a slight difference that's being pointed out there. Moreover,
all that were kinsmen at the time are disqualified. But kinsmen that have ceased to be kinsmen before become qualified.
Okay, go ahead and give an example by Rabbi Judah.
Rabbi Judah says, if a man's daughter died and left children, her husband still counts as a kinsman. Okay,
so here's the issue. And by the way, the first opinion is the one that the halacha follows, which is, all right, so I've got, we're going with man's daughter, right? So I've got a son and I've got a daughter, all right? That's a daughter, and she gets married. So that's my, we would call him my son-in-law in modern English, right? And they've got a kid, right? Or my grandkid, right? He is not allowed to testify against me, or testify about me, I should say. But if she dies, he's nothing to me. I mean, he's no longer my son-in-law because the linkage that brought him into my sphere has disappeared. Now, that doesn't mean we can't still like each other. That doesn't mean that we don't visit, or maybe he still comes to my house for Pesach. I don't know. But as far as an official reason for not accepting his testimony, he's gone. Right? And what Rabbi Yehuda says is, no, he's still there because you still have this family relationship unit that is assumed to be there. But the majority of the rabbis disagree. And they say, no, if the bond that brought someone into the family disappears, that person is no longer part of the family as far as testimony is concerned. And absolutely, you can still treat them like family and still be nice to them and everything. But as far as testimony goes, they would be an acceptable witness. And the other party, the other litigant, couldn't say, hey, but he's your son-in-law. Not my son-in-law anymore. My daughter's dead, right? So he's allowed to testify. Maybe? Make sense?
Makes sense, but it's 50-50.
Well, okay, so let's do a little compare and contrast. How do we handle these issues in American court? If my son-in-law has testimony, can he be brought to testify on my behalf?
Yes.
Yes, absolutely.
Yeah.
So, but how does the American court handle then the idea that he may be perjuring himself?
By making known the relationship.
So we make known the relationship, he could still be lying.
Yeah. You impeach the witness.
Right. So all we've got is cross-examination and the threat of penalty for perjury. That's it. And the fact is that in American courts, we have a fetish for other evidence. Witness testimony is helpful, but it doesn't have the same status as it does in Jewish courts. And so we're not as picky about who gets to testify. So what if you're a known criminal? If you're a gambler, mob boss, whatever, come on and testify. If we don't like your testimony, we'll cross-examine you into the ground, or we'll find evidence that contradicts it, and then we can maybe get you on perjury or maybe not. But we'll let it all work out. Just everybody vomit your testimony into the court, and we'll work through it.
Even pigeon racers.
Even pigeon racers. Even pigeon racers, or loan sharks, which would be the modern term for usurer, or professional card sharks or anything like that. Their testimony is permitted. Now, most lawyers will be picky about who they put on the stand, knowing that a bad person testifying might discredit their case. But it's really up to the lawyers to decide who they want to call as a witness, because it is the litigants that are calling their witnesses. It is not the court. It is not the judges that are calling their witnesses. Now, the court has the authority to call the witnesses, and that's what a subpoena is and all of that. But ultimately, it is the attorneys that set in motion the bringing of someone before the trial, not so much the judges. Whereas in this, remember, it's an entirely judge-based system. It is the dayanim, the rabbinic judges, that are bringing the people in and choosing whether or not they are fit to give testimony on any given topic. Because testimony has the place of prominence. It's, if you are giving testimony, that is more important than almost any other form of evidence. So we want to be really, really careful about who we let speak. Make sense? Okay. One more careful of who speaks, 3:5.
3:5. Mishnah 3:5 continues. Oh, okay.
Mm-hmm.
A friend or an enemy is disqualified.
Pardon?
Keep going.
But so a friend. So wait a minute. Apart from the pigeon racers and all of those guys, any one of my relatives in this rather large sphere, which if you're living in a small town, could be half the town, because you got a few, if you got, say, 10 families or maybe even 15 families, a lot of people are going to be married to a lot of people. So you got all these relatives that are disqualified and all these other people disqualified. And a friend or an enemy? Well, that's the rest of the town. I mean, I'm friendly to half of them and I'm angry at the other half. So who's left to give testimony? Keep reading.
A friend, this is one's groomsman.
Right. What's a groomsman?
One at the wedding.
Right. Yeah. Someone who helps with the wedding. And by the way, the official definition of groomsmen was somebody who actually brought food and drink and helped with the wedding, not just they stood there in the tuxedo and looked good. So yeah, a groomsman has an official capacity and is providing. And gifts of food and drink were a major gift in the ancient world. That wasn't just like, hey, I'm taking you to lunch. It was a big thing. So somebody who was willing to be your groomsman or who you would trust as your groomsman, that's a friend. Right. That's a friend. Not just the guy you sit next to in shul. This is a friend. This is material. And there is debate, however, in the commentaries of whether they're only considered your friend during the wedding period. Right? For this purpose. Not, in general, but, well, what happens 6 months later? Are they still considered my friend because they were my groomsmen? What about 2 years later, 5 years later? Do we assume that the bond of friendship, which we are suspecting may pervert the testimony, maintains at the same level throughout the entire life, just because they were there for one ceremony? And most commentators say no. that it is only for the immediate period around the wedding that the groomsmen are considered disqualified. That otherwise you can be best friends and you go on vacation together or whatever else best friends do, but they can still give testimony and their testimony is considered acceptable. Enemies, on the other hand,
An enemy, anyone whom he has not spoken to in 3 days because of anger.
it's kind of a lower bar. Right? If I haven't talked to you for 3 days because I'm angry with you, you're not allowed to give testimony against me. But what if I know something? So why should the person not be allowed to give testimony if they know something?
And also, what if you know they're going to testify? Why not just cause a fight and not talk to them for 3 days before the?
I can't talk to you. I need to make sure you don't testify.
Yeah.
So there are definitely ways to possibly manipulate this, but it's possible to keep. The rabbis do have ways to work around those particular perversions. One of the things that's very, very interesting is that in much of the later discussion in Jewish law, they take this as being that the disqualification that's being emphasized here is the disqualification for the judge, not for the witnesses. That it is a judge who is not allowed. Because if you look at the next line, that Israelites are not suspected of such. The general opinion of the rabbis, these first two qualifications, friend and enemy, are assumed to be part of Rabbi Judah's end of the last Mishnah. These first two, look, whether he's my friend or whether he's my enemy, I'm going to tell the truth. The rabbis believe that there is an inherent believability for the average Israelite coming to give testimony. And although families we can suspect and suspicious characters we can suspect, the average person, even if he is your best friend and even if he is your worst enemy, when he stands before the Beit Din, we will accept his testimony. We'll cross-examine him and we will try to ensure that it's accurate, but we will let him speak, because we're not going to start with the assumption that everybody is willing to lie for their friend or against their enemy. But the rabbis did eventually codify that doesn't apply when it comes to judges. That if somebody appears before a judge looking for redress, the judge has to recuse themselves if they are their friend or their enemy. Because I have a basic assumption of both trust and verifiability when it comes to a witness coming to the court, because the judges can check him. But who checks the judge? Right? Who makes sure that the judge is being totally impartial and fair for a friend and an enemy? We don't have another layer to cover that, so if it's a friend or an enemy, the judge has to step aside. Right, has to be disqualified. There was a lot of recusals in Jewish courts. We expected judges to step down often for reasons such as these. All right. 3:6. Now we get down. Now that we've got witnesses and we've done the the voir dire process and gotten rid of the ones who were disqualified, what do you do with a witness once you got him? 3:6.
How do they check the witnesses? They bring them in and warn them, and then they take them out and leave behind the most important of the witnesses.
All right, so they bring in all the witnesses, all the guys who were going to testify. And remember, in the ancient world, it was just guys who are going to testify about this case, about who sold who the cow, or how much did they say they were going to pay for this, or what did you see him doing to that guy, with the knife. They bring in all the witnesses, and before they get any testimony, they warn them. Right? If you lie, if you deceive, if you do not give an honest and an accurate testimony, you are in so much trouble, mister. And we talked a little bit before about the Jewish perjury laws as being a sliding scale, that if you deliberately perjure, not just inaccurate, but deliberately lie about where you were and what you saw, that you will be punished with whatever the other person was facing. So it's a very heavy and severe warning that goes on. Then you take all of the witnesses out, and only the most important witness, the key witness, you start with. Why do we get the other people out?
So they wouldn't listen.
Yeah. So they don't sit there listening to each other's story and listening to the questions that the judges are going to ask and preparing themselves in advance of how to answer.
Yeah.
It's supposed to be natural,
It's similar to what we have in this country. The witnesses don't sit in the court, I think.
Well, they can. It depends on exactly the type of trial and how things are being conducted. But for many cases, they will ask the witnesses to remain outside until they are summoned. But it's not impossible. For example, if someone had been sitting there during a court and they suddenly decided they wanted them as a witness, they're not disqualified because they've been listening to all the testimony. You bring them up. But this, start off with the key witness, whoever you think has the most relevant or important or extensive testimony to give, and let's work with them. So next part 3.
And they would say to him, state for us, how do you know that this one is in debt to this one?
Right. So this was one of the bigger, more common issues, which is one guy said he owes me 100 zuzim, or we're going to say 200 zuzim, right? I remember Hadgadyah was only 2 zuzim, but this is going to be up to 200 zuzim. It's more than just a little goat. How do you know that so-and-so owes the other guy this money? Notice how it is a general open-ended statement, right? It's not saying, what do you think this guy owes that guy? We already know what he thinks. That's why he's a witness, because he has come to testify that so-and-so owes the money. We want to know how he knows that information. Well, how did he come to that conclusion? And now we're going to evaluate some possible answers.
If he said to me, I'm in debt to him, or so-and-so said to me that he was in debt to him, he has said nothing.
All right. So even if we're going to call him the debtor for the moment, said to his other guy, you know what? I owe Frank money. And he comes to the court and says, well, he told me that he owes Frank money. And that's not testimony.
No.
That is not testimony. Right? Because did he witness anything?
Oh, it has to be with the 3 of them.
Well, it doesn't necessarily have to be with the 3, but he has to. I mean, the guy giving and yeah, exactly. And that's why we're going to be in part B. He didn't witness anything. All he did is repeat what someone told him.
Yeah.
And even if it was the guy who was supposedly in debt, he didn't witness the act that he is testifying about. All he witnessed was his guy talking.
Shmuah.
Exactly, and that's not enough. Even if it's from the guy who might have the debt, that's not enough.
Okay, so part B.
Mm-hmm.
He must be able to say, in your presence.
In our presence.
Yeah, in our presence, he acknowledged to the other one that he owed him 200 zuz.
All right, so notice that very careful phrase. In our presence, meaning
All 3 of them.
me and probably another witness were there in order that they could publicly state that there was this debt between them. And because it was convened, because it was arranged, because it was established for the purpose of me being a witness, now I've got testimony. Now when I say, I was there on such and such a date when so-and-so had so-and-so acknowledge in front of us witnesses that this was the debt, that is testimony. But just, I was at the bar and Bob told me he owed Frank $100, not testimony. That's just bar talk.
Yeah.
So again, going back to this idea that testimony is everything, but not everything is testimony. The rabbis had to be very careful of what was permissible. And just talk. They did not like to have that just come into the court and dominate. They wanted things to have been arranged, which is why when you loan someone money, you get witnesses. And if you don't have witnesses, then you're going to have to get witnesses after the fact. And that's not just getting the guy to admit, to his buddy that he owes you money. That is, look, you owe me money, right? I got two witnesses here. Could you please tell me in front of them that you owe me X amount of money? So that way we know that you owe me the money. That's testimony.
Yeah.
Make sense?
Makes sense.
Makes sense. Part 4.
Afterward, they bring in the second witness and check him.
And 5.
If their words were found to agree, the judges discuss the matter.
All right, we'll deal what happens later if they don't agree. But right now, second witness comes in and says, I also was asked to acknowledge or to be in the presence of him acknowledging the debt, and with the other witness, Then they go, okay, we got two witnesses here who agree. We've got no other evidence to the contrary. That is proof, probably. Let's decide.
Mhm.
So if
two say he's not guilty and one say he is guilty, he's not guilty.
majority rules.
Mhm.
Right, remember we said way back at the beginning, you only need 3 judges for this kind of case. So if 2 out of the 3 say guilty, meaning that he is, say not guilty, meaning he does not owe the other man money, he doesn't owe him money, and we're done.
He's talking about the judges because
Yes.
you need 3 judges.
Exactly, 3 judges.
Yeah. So if 2 say he's guilty, that's it. He's guilty.
And if 2 say not, he's not.
He's not. Yeah.
Right. So go ahead and finish off the section.
6, yeah?
Yeah.
A? Yeah.
Yeah, we're on A of part 6.
But, yeah. If 2 say he's guilty and 1 says he's not guilty, he is guilty. If 1 says he's not guilty and 1 says he is guilty, and even if 2 declared him not guilty or declared him guilty while 1 said I do not know, they must add more judges.
All right. So it's a very, very interesting caveat here. I'm going to try and illustrate this because it's
Complicated.
it's not complicated, but it's so different than what we're used to in our own judicial or other types of proceedings, right? So you've got Judge 1, Judge 2, and Judge 3. And in this last section here, part B, you've got Judge 1 says guilty. Judge 2 says not guilty, right? So we seem to be having a tie. And Judge 3, if Judge 3 says guilty, what's the verdict?
Guilty.
And if he says not guilty,
Not guilty.
very good. And if he says, I don't know, what's the verdict?
They have to increase the judges.
Add another judge.
Or 2 to make it 5.
Judge 4.
But back up. But the way I read this, what if 1 and 2 are in agreement?
So that was also the very interesting thing, right? So let's back up before we get to Judge 4. What happens if you have 2 of them saying guilty,
Right.
and 1 of them says, I don't know? Judge 4.
What difference does it make?
Exactly. If he had said not guilty and they had said guilty, then he would not be guilty. I mean, he would be guilty because it's 2 against 1. But 2 against none means that he was not able to participate fully in the deliberations. If he can't reach a verdict, it means the evidence is still unclear on some level. And it's the responsibility of a judge to reach a decision based upon the evidence. If he can't, how could they? Right? If he doesn't know from the available evidence, how could they have known? Now, he could come to a different conclusion, and that's fine. Then there's reasoning of judges and reasoning of other judges, and they can be in contradiction. But a judge is not allowed to just say, I don't know, without making the whole trial come into suspicion that there was something missing from the deliberation. Because judges are supposed to be able to know. That's their job. That's by definition, a judge should be able to judge. And if he couldn't judge, then there's a gap somewhere here, and we need to fix that gap by adding in more judges that can judge.
What happens when they go to 21? And 20 say 1 and the other says, I don't know.
Right. So if you go all the way up to the top, and you still, then yeah, up to the Sanhedrin Gadol, the big Sanhedrin, then you go by majority.
Okay.
But so yeah, there is an appellate system of just adding, but eventually you do tap out, and you're done. But yes, for low level, we can get away with adding judges for a while before we get to that problem.
It sounds similar to what we have in this country. I forget how they call it, that dead jury, hung jury. Yes,
Yeah.
hung jury.
Right.
Very similar. Yeah.
No.
It sounds like same idea. No?
If someone says, that's.
A hung jury says they can't reach a
It's a
decision,
decision. Yeah.
right? Not necessarily, but a hung jury is often, they all have their opinions. They've all reached their own verdict, but the jury cannot agree upon that verdict. This is saying, not that they're fighting about it, but that he's just out of the question. But notice, I mean, for example, if he says, I don't know, essentially he has erased himself from the whole system.
Being there, yeah.
And if you did that, there would only be 2 judges, and you're not allowed to be judged by 2.
Yeah.
So you have to bring in a 4th judge to fix the gap that guy has left.
Yeah. So basically, Judge 4 will be
Judge 3.
3. Yeah.
Right. He is technically the 4th judge, but his verdict will be the 3rd verdict,
Opinion. Yeah.
the 3rd opinion, and we need 3 opinions.
It makes sense. It makes sense.
I think so. I'm biased, but I think so. You know the old joke: 2 Jews and 3 opinions. We need at least 3 opinions. So yeah, we need to get this guy replaced by someone who can actually make a decision.
Make a decision, yeah.
All right, we can still move on to 3-7,
3-7.
which is a beautiful little bit. I love this section because it's so different than what we currently get.
1. When the judges reaches their decision, they would bring in the litigants.
Oh.
Makes sense.
Right. All right, guys.
You have to do it in front of everybody.
Of course.
Public.
Yes.
It's a public announcement. Yeah.
And you're making, but you're not. Remember, it's not an announcement.
Yeah.
You are creating or dismissing an obligation.
Yeah.
Right. Until the judge says something, the bond between these 2 people is unknown. It's that quantum state of flux. You know, he owes him money and doesn't owe him money at the same time. He has to repair the house and doesn't have to repair the house at the same time.
No judgment.
Right. When they speak, it becomes
Judgment.
1. Right. The state collapses into a single probability. Okay.
2. The chief among the judges says, you so and so are not obligated, or you so and so are obligated.
Pretty simple, right? Chayav, patur. We're done.
Yeah.
Obligated, not obligated.
Yeah. And that's usually probably the chief, the more
The more learned or respected of the judges. Exactly.
Yeah. Okay. 3. And formally we know that after one of the judges has gone out, that he may not say, I declared him not obligated, and my colleagues declared him obligated. So what can I do since they outvoted me?
All right. So you don't do that. If you were on the judgment, and remember, because they're deliberating without the people present, right? They got the testimony. They know whatever evidence has been presented, and now they're talking amongst themselves. And 2 of them say he's guilty, and the 3rd one says he's not, and they argue and argue and argue, and they stick with it, and they say, okay, 2 against 1, he's guilty, right? He has to pay up. They bring the litigants in. All the judges sit there. One of them says, he's guilty, please pay. We're all set. Yeah, the 3rd guy doesn't get to go out and go, you know, I disagree with them, but they outvoted me because I thought you were right, man. I don't know what they were smoking, but it's
There is no minority opinion.
there is no minority opinion. There is no minority opinion. When the Beit Din has spoken, it speaks as one. And it becomes a, well, I mean, look at the description. We'll use their text first, and then we'll talk about why. But part A says
Part A, of such a one, it says, do not go about as a talebearer amongst your people.
a gossip.
Yeah. And it is also says, he that goes about as a talebearer reveals secrets. And it's from the
Mishnah, Proverbs.
Yeah. Proverbs.
So he's not lying when he goes out and says, I voted, to let you off the hook, and they've outvoted me. He's not making it up. We're assuming at the moment that he's honest about this. So why not? Why not let him go out and say? I mean, nowadays, how many times do they interview juries to find out why they voted the way they voted on the jury system? Or how many judges do go on to explain in great detail exactly how they reached their verdict, or why they disagreed, for example, in the Supreme Court with the verdict of their colleagues? So we come from a society where talking about the decision-making process in this kind of way is commonplace. Why would the rabbis have said that the Torah considers that gossip?
Other than it's in secret, you're not supposed to reveal secrets.
So, well, part of it is secret, but part of it is
Maybe it's like publicly disagreeing with the other judges is like a disrespect, maybe to those.
more than that.
More than that.
It's disrespect, but it's more than that, right?
Albanat panim.
It's not exactly humiliation, but when they say, this goes back to sort of what I was saying about the whole, quantum flux thing. When they say you're obligated and you're not obligated, they are creating a status of Jewish law for that person. They are saying, in the eyes of Torah, in the eyes of God, this is your status. For someone to say they disagreed is to say that status may be wrong.
Yeah.
Which is more than just go to the appellate court or we'll have another argument about this. It is basically saying we have no idea what Torah says about this. But God doesn't know. People don't know. The Torah, we can't help you here because they got Torah wrong. They misunderstood God of what God wanted from this application. I knew what God really wanted. They didn't, but I got outvoted. The Beit Din speaks to be the interpreter of our tradition in order that it can be applied in this world. And once they have spoken, that is the status for that situation. It's not an application, it is a creation, right? Judges are partners with God when it comes to creating the status of guilty or innocent or liable or not liable. And to go back and try and explain to other people that you disagreed with that status is to undermine the entire system of what we are trying to do. Right? It is the judicial procedures in Judaism is not like Sherlock Holmes looking for the evidence that's already there in order to come to the objectively true conclusion. It is an inductive process that creates the conclusion by its pronouncement. And to tear apart the process that created that conclusion is by necessity tearing apart the system that says this conclusion was created. It's like in before the modern world, it is like casting doubt on the paternity of a child and saying, I saw your wife with somebody 9 months ago when you were away for the weekend, and that kid kind of has his eyes. Once you say something like that, and there's no way to, in quote, check, because they had no paternity tests in the ancient world, or even in the modern world until very recently, and there's no way to erase that suspicion.
The whole process.
Who do we believe? Who do we trust? How do we know where this child came from, right? And this is saying that's why you don't say that.
Actually, in the explanation, they say that it's if there is a disagreement, the person, the judge that disagrees should not talk about it.
Correct.
Yeah, should not talk about it.
And we have a very, it's what's officially called a logical positivist view of law in Western society. It's thank you to the British and American system of legal tradition, where there is a popular feeling. Most judges and lawyers don't really go down this road, but there's a popular feeling that law is a computational process that you take the law, you add evidence, you hit enter, and you will have the verdict that will match law plus evidence. And that's it. And as long as you have all the evidence and as long as you have the correct law that's being applied, the verdict will be the same no matter how many times you hit enter. And this is saying, no, it's not computational. It is creational. That we are creating the status of guilty or not. The American system is we are inventing guilt or innocence. Now, note, the real American jurisprudence, scholars of jurisprudence don't think like that. If you read actual scholars of legal theory for American law, it's not. Remember, when they say not guilty, they don't say innocent. Right? They say we cannot find enough evidence to convict this person as being guilty. They are not claiming one way or the other to have objectively discovered the truth of this person's status. They are simply saying our court has rendered this verdict. That's what this is saying as well. But it's trying to protect it from what we see in American law, which is defends itself by veiling itself as being objective and always true, when it clearly isn't, but we pretend like it is because we're uncomfortable by this realization. In Judaism, we admit that we are working to create justice. We are not simply objectively uncovering the dirt in order to find it. We are making what is right or wrong in any given situation to the best of our ability. And if you besmirch that process by going out and saying, well, they were wrong and I was right, but I got outvoted, then the entire process collapses. And that's one reason why we don't teach a lot of jurisprudence in American law, because we're afraid the entire trust in the system will collapse. And some of the issues we've seen recently with the American Supreme Court and with many other judicial issues around the country, especially in many of the issues of minority rights, come down to exactly that problem, that people in many communities no longer feel that the judges are judging fairly.
Correctly, yeah.
Right? Because they hear too many alternative opinions that cast doubt on why the other judge did that. And although it is fine to review and it is fine to analyze and discuss, which Judaism has, like I said at the very, very beginning, a huge library of literature of discussing previous decisions and the underlying principles and how that would apply in other cases, we never second guess the verdict that was reached for that particular case. We second guess the next case in order to make sure we do a better job in the future. Whereas in our country, we now have a very strong tendency to second guess constantly based upon our political views, our racial views, or our cultural views, the decision of any judge that is reached if it contradicts the decision I wanted it to reach. And that's a problem, because once the legitimacy of a court is called into question, it is very, very hard to reclaim that legitimacy, because people begin to no longer see it as being a mechanism for judgment. It is a mechanism for political, cultural, racial gain, whatever. And then when people stop listening to the court, when they stop believing that there can be justice or proper judgment in their community, they find their own solutions. And usually those are not as good as having a well-reasoned court handle the projects. Sometimes it is important to overthrow obviously corrupt judges. And Judaism does have many issues, and we'll get to them later, of what happens when you have a corrupt judge and what happens when you have a corrupt city and corrupt society that is not pursuing justice, even though they're, in quote, following the procedure. But the starting point has to be, we accept the rulings of the court, that we accept that the court is creating answers that are appropriate for our community and for our position.
In this Jewish process of judgment, is there a way for appeal?
For certain types of issues, yes, absolutely. And if you can establish that we're going to see also about bringing late evidence to the issues, and also when judges make complete errors, where they just got it wrong. We'll talk about those as well.
It's later.
It's later, but you'll notice the way the Mishnah was written. We start with the idea that what is judged should be accepted. And then we add the exceptions. rather than saying, there's all sorts of reasons why judges get it wrong, but occasionally they're okay. We start with, you accept what they say.
Positive.
The litigants should accept it, and the judges should accept it. And if there is some obvious reason why we need to have a challenge to this, then, well, later we'll talk about the process that goes for those challenges.
Okay.
So it's not what the judge says is done, go home, but that should be the default position. There are ways to challenge, but the challenge should not be the natural state. It should be acceptance, both of the litigants and the judges. Steve, you look like you're lost in thought.
I'm trying to, doing the parallel to the American system.
System.
It's almost like the Torah is the Constitution,
In many ways.
and the judges should have no biases. So the people on the Supreme Court in the United States should have no biases, as long as they seek the wisdom in the Constitution.
Correct.
And therefore, we 9 people have deduced the truth.
Deduce the correct application of the Constitution for this case. Correct. And that is, in theory, what the Supreme Court does.
Except you introduce biases and political.
Well, and partly we do that because we can do that. The politicalization of the court became possible when somebody woke up and realized, you know, we can put judges on that we can hope will vote in our favor. Now,
You wanna name names?
well, I mean, historically, for example, you know, unless there was an egregious issue with a judge, somebody who was nominated to the Supreme Court usually went through on the nod. But as people began to realize that legislation was becoming harder and harder to achieve because there wasn't as much agreement between the parties on compromise, that the courts then were going to become where legislative outcomes would be reached because they weren't happening in the Congress and the Senate. When people realized that, and people also realized that although the term for life was intended to isolate a judge from political influence, that you wouldn't have a hold over some judge that you appointed. So, okay, fine. So I'm a Republican or I'm a Democrat, I appoint a judge. He's not beholden to me. So once he's on the bench, he can be free from that political influence. Once people began to realize, well, actually, a lot of judges do continue to vote ideologically. And there are other ways that they can be influenced through relationships with spouses, with families involved with other companies. There are ways that a judge would be more likely to vote consistently with an ideology that matches the person who appointed them. When people began to realize those were options, then the Supreme Court, yes, has become more suspect in the eyes of many. But judges for the ultimate Sanhedrin were appointed by merit.
But how do you prevent any ideological biases? I mean, even the Catholic Church, there were conservatives and there were liberals. So
Correct.
There had to be the equivalent.
And there were debates among them for many issues, which is why you make a large enough body that you have room for all of those. I mean, remember, the Sanhedrin Gadol is almost as big as our American Senate. And you have room then for those, but you still have a majority. And the majority votes. And the majority is not beholden to any special interest. It's not beholden to campaign financing. It's not beholden to a democratic election, which we might consider to be a problem. But when it comes to making unbiased opinions, knowing you don't have to go and defend yourself at the polls can be helpful, especially if there are other ways to balance out that kind of power by things that are popularly influenced. So it did provide a certain level of objectivity within the Jewish court system. And it's not perfect in the sense that it doesn't always create unanimity and harmony and all of that, but there are a number of safeguards to prevent it. One that we'll get to eventually is if you have a unanimous court in a capital punishment case, then the court is considered to be wrong. If everybody votes that the guy needs to be executed, something went wrong during the trial. It's, it's like guilty, 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 and down the line. then it was if no one on the court found reasons to not execute, not that the person was innocent of the crime, but that the crime was not committed to meet the criteria that would require capital punishment, if no one in the court had enough doubt to say he's not liable for death penalty, but for some lesser penalty, then the court was considered biased. So there were some internal safeguards, and we're going to see that when it comes to how people express their opinions on the court. For example, in capital cases, I'm giving spoilers here, the most junior members spoke first rather than the most senior, because there was a concern that the most senior people, who were considered the wisest, they say he's guilty, but he's going to influence all the other guys. You know, what rookie is going to contradict the head, the Nasi? He says he's guilty. I mean, he looks innocent to me, but all the evidence seems innocent. But if he said he's guilty, he must be. So you start off with the rookies, and that way you build up. Although in certain other types of cases, you do start with the most senior, but we'll get to that. Well, not tonight. That's actually 1 week, 2 weeks, 2 weeks. No, next week we should get to that. Next week we should get to some of the in Mishnah 4. In chapter 4, we should get to some of the safeguards that are built in to try and prevent the court from having too inherent of bias for certain types of answers. But that's it for tonight.
Thank you, Rabbi.
Thank you.
What just happened? Where's my mouse? There we are.